Adrianne, we went to you first. Perhaps you want to give us a couple of your final thoughts from today.
Well, I wanted to, if I had a couple of minutes, talk about voluntary disclosures and the importance of voluntary disclosures if you do find yourself with a potential violation on your hands. Voluntary disclosures can be made to OFAC and to the Department of Justice. Department of Justice just put out a policy on this back in December, and there are significant advantages to doing voluntary disclosures to OFAC in terms of civil violations and to the Department of Justice if you think there is a willful potential criminal violation. And I would just encourage companies to gather the facts yourselves and make a disclosure to take advantage of the Department of Justice's program and all the advantages of doing a voluntary disclosure to justice. You have to disclose to the Department of Justice separately and not just to OFAC. So if you do think there are potential criminal penalties, disclose both Department of Justice and to OFAC. And while, as Glenn mentioned earlier, you're not going to get out of jail free, you will do yourself a favor and significantly reduce penalties. Thank you very much.
Thank you so much, Adrianne. Glenn, a few key takeaways from yourself as well, please.
Yeah, absolutely. Thank you, Andy. Thank you, Adrianne and Kevin. When in doubt, check with OFAC and always assume that you're dealing in block property. It's the old adage: whenever there is any doubt, there is no doubt. You're always going to be better served if you can taking a moment and double checking and verifying before engaging in transactions to make sure that you're not dealing in block property or dealing with a designated national. The updates happen all the time, and which is why the importance of self-disclosure in the event of a violation, as Adrianne was just talking about, because there are frequent updates and frequent changes, and there are also amendments to the rules, and be very vigilant when dealing with OFAC, because just because the sanctions announcement or proclamation that they have given on the specific issue potentially of interest to you may be limited or somewhat confusing. As Adrianne referenced, there is a frequently asked questions page that is frequently updated by OFAC that may contain broad prescriptions against certain conduct that may be held applicable to each section. So be very thorough when dealing with potentially blocked assets, property, or individuals, and when in doubt, ask.
Thank you so much. And finally, Kevin, we heard from yourself. Perhaps you want to close us out with a few of your key takeaways as well.
Okay, thanks, Andy. I guess two thoughts. One is in taking a look at the recent enforcement activity, both in the banking context and the non-banking context, what we see are sort of two varieties of violations, if you will, purposeful and not purposeful. The purposeful ones are oftentimes the result of sometimes non-purposeful activity that is then being hidden, and certainly can escalate significantly the penalties that are imposed in those situations. I would venture to guess in many cases what we have are sort of the failure to have an adequate compliance program in place that would have picked up issues had that been in place. So in both cases, purposeful and non-purposeful, it's critically important to have an effective compliance program for insured depository institutions and any other businesses that have significant financial activity involving international commerce. The second point that I would note, and I think this is something that we didn't really spend too much time on, I did mention it in the BACB case, the complexity of the legal theories that OFAC and the federal banking agencies are pursuing, Justice Department are pursuing, is becoming more and more sophisticated much more challenging especially for banks operating internationally, in the sense that if there's a U.S. dollar tagged to a transaction, and then somewhere in that transaction there is an SDN or the sanctions violation with a country on the sanctions list, the regulators, OFAC, will significantly review those types of transactions to see if there's some sort of hook that jurisdictionally that they can make to get at the activity, regardless of whether the entity is a U.S. person or not. So while OFAC does have constraints, as Adrianne noted at the outset, that it has to be a U.S. person, what we're seeing is more and more efforts to try to sort of deputize U.S. persons to get at other folks who may not have such an obvious link to the jurisdiction of OFAC, but OFAC nonetheless has been very active in this area.